Welcome Dr. Shetty to Editor Speak. Nowadays there is a concept called a negative consent. Is it a common parlance जैसे हम बोली भाषा में कहते हैं, or is it a known word in the medical text?
It is not a part of medical text. This we have been hearing of late in India. It is neither a part of medical text nor a part of textbooks of law. When a patient refuses to give consent or a patient's relative of a patient who is not competent to give consent refuses or to give consent, then it is called as negative consent.
So then what does a doctor do if a patient or a relative delays or refuses to give a consent?
Explain to the patient the need for giving consent. If there is a delay or refusal in giving consent, and if that delay or refusal causes complication or may cause death, explain the consequences to the patient or relative for refusal or delaying consent. If the patient still refuses, record specifically in the medical records.
Sir, could you illustrate this with a real life case?
In a recent judgment from the National Consumer Commission, a patient was brought to the hospital, a pregnant woman, cesarean was performed, complications occurred, patient was transferred, patient was declared brought dead to the other hospital, even the baby was declared brought dead to the other hospital. The relatives filed a case of negligence. They had many allegations against the hospital and the doctors. But one specific difference taken by the doctor stood out for me. The doctor stated that there was negative consent and the consent was given after a lot of delay. But the court rejected this outright. They did not find the mention of this negative consent nor the delay in consent, and hence the doctor was held negligent.
Sir, another aspect which is becoming very common is where a patient or a relative refuses to give a consent orally but is not ready to give it in writing. In such a situation, what should the doctor do?
When a patient refuses to give consent orally or delays in giving consent and refuses to acknowledge it, specifically mention it in the medical records. Court trusts the noting by a doctor in the medical records, and the problem only occurs when the doctor thinks this is very insignificant, and that is when he lands up in trouble in cases of negligence.
Sir, so what would be your take-home message?
My take-home: documentation plays a big role in cases of negligence. Any refusal, any delay in giving consent should be specifically recorded in the medical records. Had the doctor mentioned the refusal or the delay or the negative consent in the medical record, maybe the courts should have given a favorable verdict to the doctor.
Thank you, Dr. Shetty, for your valuable insight.
Thank you.